This unit is on supervision. Rules 5.1 through 5.3. These rules deal with the comparative responsibilities of law firm partners, lawyer supervisors, and supervised lawyers. Rule 5.1a establishes that a partner in a law firm must make reasonable efforts to ensure that the firm has measures that give reasonable assurance that all the lawyers in the firm conform to the rules of professional conduct. This is a managerial responsibility. It means that there must be internal policies and procedures designed to deal with ethical issues that will arise, from procedures to screen for conflicts, to procedures to ensure diligent processing of legal matters, to procedures for dealing with client funds. Exactly what these procedures must be will vary given the size of the firm and the nature of the practice. One excellent process that medium to large firms employ is the use of a legal ethics panel to resolve ethical questions. Junior as well as senior attorneys might refer questions to such a panel, which would assure that the firm was making the correct decisions in matters of professional conduct. As we have seen, firm doesn't just refer to the private law firm. Accordingly, this managerial responsibility is also imposed upon attorneys with comparable managerial responsibilities in governmental offices or nonprofit legal service programs. Rule 5.1b addresses lawyers having direct supervisory authority over another lawyer. Such supervisory lawyers must make reasonable efforts to ensure that the supervised attorney conforms to the rules. Rule 5.1c deals with when the supervisory attorney is responsible for the ethical violations of another attorney. If the managing or supervising lawyer orders the conduct or, knowing of the conduct, ratifies it, the supervising attorney is responsible. Similarly, if the managing attorney or supervising attorney learns of the conduct at a time when its consequences can be avoided or mitigated and fails to take remedial measures, then the managing or supervising attorney is responsible. Note that this responsibility for the conduct of another is responsibility under the rules in the disciplinary context. This does not address whether the manager or supervisor would be responsible under tort or contract law. Finally, note that there are two separate paths to responsibility. One, by failing to make reasonable efforts to ensure proper behavior, and two, by ordering, ratifying, or failing to take remedial measures when a violation of the rules occurs. Rule 5.2, Responsibilities of a Subordinate Lawyer. Subsection A declares that the subordinate lawyer is responsible for her acts, notwithstanding that she acted at the direction of another. There is no defense of, "he made me do it." Of course, as comment 1 notes, the fact that the associate did what the partner ordered might be relevant in discovering what the associate knew. If only the partner knew that the pleading was frivolous, and the associate merely acted as draftsperson, she would not be responsible for violating the rule. Subsection B states that the associate does not violate the rules if she acts in accordance with the partner's reasonable resolution of an arguable question. Thus, if it is clear what the rules require, and both the associate and partner act with knowledge, they are both in violation of the rules and subject to discipline. However, if the ethical answer is unclear and the partner chooses the way to proceed, then the associate will not be in violation of the rules. Rule 5.3, Responsibilities regarding non-lawyer assistance. This rule is parallel in many ways to Rules 5.1 and 5.2. It deals with the responsibilities of both partner managers and supervising attorneys with regards to non-lawyer employees or contractors. This includes paralegals, clerks, interns, secretaries, and investigators, for example. 5.3a imposes duties on partners and other managers to make reasonable efforts to ensure that there are measures giving reasonable assurance that all employees' conduct conforms with the rules. These reasonable measures should include instruction and supervision about such things as client confidentiality. Subsection B addresses lawyers having direct supervisory authority over a non-lawyer. Such supervisory lawyers must make reasonable efforts to ensure that the supervised non-attorney conforms to the rules. Subsection C deals with vicarious liability. It states that an attorney is responsible for the misconduct of a non-lawyer assistant if the attorney orders or with knowledge ratifies the conduct, or if the attorney fails to take remedial action when the consequences could be avoided or mitigated. This is the conclusion of our discussion of attorney supervision.